these administrative hearings, the other thing is that when you prosecute things through the criminal system, then people end up with a criminal violation on the record. And it could be that all they did wrong was refuse to mow their lawn. So I guess you have to kind of ask yourself, is that really, the kind of thing that you want to handle through the criminal system? I think most cities nowadays are deciding that there's a better way to do it. That's essentially...
One of the questions I've got in here talks about an administrative law judge. Who would that be?
Well, I let Ed answer that. It speaks in the ordinance that who it can be. It can be either somebody who's law trained. It doesn't have to be. It can be someone who just has a lot of experience in code enforcement issues. But I think Ed has an idea in mind.
Ron Flam. Currently, the judge in the criminal court, he sees these cases, but not on the administrative side. I've talked to him, and he's okay with taking that on, because he'd be doing it anyway if we were to bring it to him in that case. But it's something that the mayor's got to, if you read in there, he's got to recommend a name to council for you guys to approve in a resolution form. And we'll do that on the 28th or the meeting after that, if you guys pass this ordinance tonight. But that's what I'm recommending. I've talked to him already. He's okay with that. We're not paying him any more than what we pay him. It's going to be the same. We'll just see how it goes for a couple of years and see if we have to go a different route.
And some of the city's parking violations have been decriminalized, and Judge Lambert's hearing those in kind of a civil context. So he just puts a different hat on, and different rules apply, different procedures apply. But he could continue to be if you were appointed by the mayor and confirmed by the city council, he could handle those hearings.
Other questions, Red?
Thank you, Mr. Mayor. Just had a couple questions here on both of these. I guess since we're talking about the administrative hearing, I'll just hit those first. The administrative hearing, how is that going to differ, or will it, from a criminal trial, or if somebody was brought in right now? Is the process different? Can people still call witnesses or bring evidence? Is there going to be, I guess I'm kind of wondering what it would look like differently in the administrative process, or is it just going to be pretty much the same but now called the administrative process?
The main difference that you'd see is that there would be no lawyers in the hearing. It would be the city's code enforcement officer presenting the city's case, and usually the city's case is going to consist of photographs, and it would probably be the property owner or business owner representing him or herself. It would all happen at one hearing. You would have an administrative hearing officer that would hear the city's case, would listen to the property owner. There is the right to bring in evidence, to cross-examine witnesses, pretty much all the rights that you'd have in a criminal hearing. But it probably would take place in about a half hour or 15 minutes. That's about how long those hearings generally last. Whereas in a criminal hearing, you'd have an arraignment, you'd have a pretrial hearing, you might have more than one pretrial hearing, and then eventually you'd go to trial. It would take, in the best case scenario, several months. If somebody really wants to drag it out, it could take over a year. And some people do. They know that they can drag them out, and they can make it last a long time.
So are there some potential cost savings, I would imagine, as well, in terms of administrative hours and things associated with this, or is that not really one of the benefits?
I think it's very, I don't think there's any comparison in the efficiency of, from the city staff's point of view. It just gives city staff a whole lot more effective tool to deal with these problems. And, there's probably a lot of code enforcement that doesn't happen just because there is no efficient tool to deal with them. The only tools that are available are really not that easy to use. So a lot of things go against it.
Okay, I had a couple questions too off page 6 of the proposed ordinance. that was with item number 5, paragraphs 1-9-22. The lien, kind of the same question for the 1-9-23 prohibition against municipal permits or services. Does that language, the city shall withhold city utility services, does that bind us that it has to be done in every case, or is there some ability to?
Well, if it says shall,
Discretion.
that is mandatory.
Okay, so when would that take place? In the same question above, the lien, whether the city, either acting on its own or through a private contractor, is required to abate a health or safety violation existing on real property, it shall follow the procedures outlined in Utah code. So, I guess I'd wonder, is that the normal kind of language that we would see in these, or is that gonna give room for complaints if in one case we don't, withhold the services, and in another we do, and they, grounds for saying, well, it said this city shall, but they didn't in this case, but they are on me. Just trying to think if that could, cause us problems down the road.
Tell me again, which ordinance are you looking at? Are you looking at the code enforcement or the
The
administrative?
code enforcement, yes, the one we were
And what
discussing.
was the?
1922 and 1923.
Both of them just have shall in there, and I'm just, asking if it is indeed that we will do this every time, or if not, I would wonder if, we should have something that isn't shall, if this is a discretionary item.
That's a good, I don't have an answer for you on that, other than you've identified, what you've identified is correct. If it says shall, then the city should do it every time. If it says may, then, and there's evils on both sides of that.
Yeah.
Shall will help us be consistent, because that's part of the order of things. There are several letters, phone calls. There's a lot that the code enforcement officer tries to do to get them in compliance, so they don't just run right to the lien and doing, there's a lot that we do. In fact, probably a month, 2 months, or whatever it takes, we try to work with them as much as possible. If they're just not going to work with this is the last resort.
And I think that's a good point that Ed makes. As a practical matter, this procedure is only going to be used for those property owners or citizens that where the city has run out of options. They've tried working with people, they've tried giving them warnings, tried to help them solve the problem in another way, and then this is the process that's used where you have to make somebody do it. And the lien, the reason the lien is in there is the lien procedures were already established by state law, and the city follows those. The only reason that they're in there is just to give a mandate to city staff, because there's certain, the lien has to be done right or you can't get a lien on the property. And usually the way that works is, if the city just, we just went and got the search warrant to clean up this home that's been vacant and causing concern for the neighborhood. And the way that works is the city hires a contractor goes on the property, cleans it up,